Welcome to The Law Matters. I'm Debbie Morais, your host and moderator. This is your source for legal information and frequently asked questions on a wide variety of issues that we cover, some contentious, some critical. We continue to provide resources and information that are ripped from the daily headlines or sometimes just within your daily life. This is a basic overview of legal processes, details, relevant cases, and sometimes entertaining anecdotes. We hope that this helps you handle your issues as you go through the legal process. Law Matters is a public service, and we are trying to help you to protect yourself, your family, and your business, whether you choose to work with a legal counsel or work pro se, as we say, a do-it-yourself matter. Either way, of course, our goal continues to be to help you to save time, money, and achieve the best possible results. Attorney David Bazar with the Bazar and Associates Law Firm in East Providence continues to offer his experience, perspective, and his valuable insights on all of the topics that we address. And today's topic is nonprofit organizations, the do's and don'ts, the pitfalls, how to avoid them. So many worthwhile causes and charitable organizations, they rely heavily on the spirit of volunteerism, and it's wonderful. They select members to serve in leadership, either as an officer or as a board member. So your good spirit of doing good needs to be guided and with good, responsible governance and compliance. Those are the issues we're going to address today. We want to help you avoid the consequences of conflicts of interest and some personal liabilities that could get you into trouble. So let's look at what you need and why you need to do this. So, David, it cuts a wide swath to say something is a nonprofit. Who is included in that? I know religious organizations, name a few others.
There are a lot of different organizations that would fall under the umbrella of a nonprofit, and some are nonprofit with tax deduction benefits, 501c3s. Others are just nonprofits, and we're not including all those businesses that don't make a profit. So,
yes.
Different types of examples. Private schools, are nonprofits, and those are 501c3s. You can make a donation to the school and take it as a deduction. Country clubs can be nonprofits. They're just a group of members who have organized to do something as an association. There are historical associations that are nonprofits. It can come in a wide variety of things: food pantries, service agencies for seniors, those types of things.
So some for-profit organizations or businesses also have a nonprofit segment to them. Perhaps it's geared towards the educational component or some public service that they're providing apart from the silo, which is for-profit. That can get dicey. Right. But whether it's nonprofit or for-profit, they both exist as business entities. So as such, they have some requirements and regulations about incorporation. Can you go through?
Yeah, all corporate entities have certain requirements and regulations which are regulated by the state in which it's incorporated. So a for-profit corporation registers under the different, you have choices as to exactly what form or entity you want to create. It could be for profit. It could be a stock corporation, which could be a subchapter C or a subchapter S corporation. It could be an LLC, which can take certain tax benefits either as a sole proprietorship, a partnership, or a corporation. There are partnership organizations that you can form. So there's a wide variety, limited partnership organizations. There's a wide variety of different ways as a for-profit company or entity that you can create it under the rules of the state. Nonprofit organizations or associations can also form under a few different rules, but they have to also follow the same process of incorporating or forming and filing with the state to be recognized as an entity.
So a nonprofit, which is our focus for today, they too would be having an article of incorporation that would include what kinds of information? Right.
So it would include the organizer of the organization or the incorporator. You could call it the founder.
Could be a founder.
Yeah. The all organizations registered with the state need a home office or address and a registered agent for service and an address for that agent to be served if there's any legal process that's being taken against the organization.
they all have to have bylaws for-profit and non-for-profit?
So
nonprofit?
There are bylaws, or depending on the type of association that you would have, articles of organization are filed, bylaws are filed, and in your creating documents, you can also have certain limiting information that you put in there as well. But usually, when I file something like that, we try to keep it as general as possible in the articles of organization or the forms that go to the state, and any regulations on how the organization is going to be run, we usually do by bylaws, and in the bylaws themselves, the process for which those can be amended.
So would one who wants to start a nonprofit need to look at the state level to find out what the requirements are, what the regulations are, what forms they need to fill out? Is that something that could be considered a do-it-yourself, or do you really need a lawyer to do that, do you think?
I think it would depend on what type of organization you're going to file, and some things you can do yourself. Just like for a company, sole proprietorship that you have that you want to form an LLC for, or a business organization, you can file those papers yourself. It's the legal advice that goes beyond just the filing that's important, and that's where you might need an attorney. But to just file the paperwork with the state, many times you can do that yourself. Having
been through that several times myself, I know that it was helpful to have a reference and then to meet with an attorney to go through the issues that might be encountered that I couldn't possibly encounter. So
right, and
there was value there.
Those are the bylaws. That's the information that you need to really have some legal advice on, in terms of how is the organization going to be run, how many people are going to be a quorum, is there a board of directors, and what is the role of the board of directors, is there an executive director, and who does the executive director answer to, and who tells the executive, who hires or fires the executive director, all of those types of things.
So let's talk about money. Nonprofit organizations, some of them are more than solvent. Some of them do a fine job when you look at their bottom line. If you're a nonprofit, that does not mean that you can't invest money or have a good deal of money. It's a matter of what you do with it. Could you explain that a little bit? Because there is a distinction.
There is. A company that's a nonprofit doesn't mean it can't make money. What it does with that money is really what differentiates that organization from a for-profit organization. For example, if you're a private school, you can run your school and you can make money, and that money goes back into the educational process that you're doing to maintain your campus or to improve salaries, that type of thing. You don't distribute profits to shareholders like you would do in a for-profit organization. That's the key difference. So you form your nonprofit, you make money at the purpose that the organization was incorporated for. That would be for a country club to run a golf course, if it's a golf course, for a school to run a school. Now, all of these organizations may make money at non-related enterprises. For example, the school may rent out fields, the golf course may do weddings, those type of things. That income is not necessarily tax-free. And I'm not an accountant, so we'll just say that up front, but there are rules that go into at what point in time does that kind of income become taxable. And it can be taxable even though you're a nonprofit if it's unrelated to the nonprofit activities that you're registered to do.
Or what the mission is that you have listed somewhere.
Correct.
So people often complain about an executive director for a nonprofit and have snide remarks. That nonprofit doesn't look like it's a nonprofit. That is one hefty salary. That's legitimate, though, is it not?
It's absolutely legitimate. You're running an organization just like you would be if it was a for-profit corporate business or whatever that entity might be. The same amount of work goes into that. Salaries are paid. I'll use the example again of a private school. Just because you're working for a nonprofit private school as a teacher doesn't mean you're not entitled to be paid. Just because you're the head of school of a nonprofit school, that's a private school, doesn't mean you're not entitled to be compensated. Of course you are. and you're doing a very important job for a mission that's very important. So to be compensated fairly and in accordance with what all the other like kind of nonprofits in your field would be is not unreasonable or unfair.
What about those who become members of the board? Are they allowed to be paid, make money? Are they allowed to or not? Some do, some don't. What are the distinctions?
In the for-profit world, directors of organizations are very well compensated, and they're paid for the meetings they go to and paid for other work that they do. In most nonprofits that I'm familiar with, you're not compensated for that, and there's no expectation of compensation. But there are some where you're at least compensated for going to the meetings or the travel to the meetings and that type of thing. And again, if it's a national nonprofit and you have to go from Rhode Island to Washington, D.C. perhaps to be compensated for the travel to do that or for attending the meeting is totally reasonable and understandable.
Is that a taxable event for the recipient?
Not usually if it's compensating for expenses. If it's compensation for your time to attend the meeting, that could be taxable.
Okay. And when someone is agreeing to join a board of a nonprofit, sounds like a wonderful and kind gesture. What do we need to know about the responsibilities, and in particular, some of the personal liability and risks and the fiduciary responsibilities? Go through some of those if you would.
So if you're a volunteer on a nonprofit board, a director, board member, whatever your organization may call it, there are responsibilities to the organization. Those are your fiduciary responsibilities. And in running the organization, you're supposed to make good, reasonable decisions. So one of the questions I would ask before I joined a board is, first and foremost, you don't plan on making any mistakes and you're going to do a really good job, but in the event somebody doesn't think you did and there's going to be some type of lawsuit, is there errors and omissions, directors and officers liability coverage to protect you? Most organizations will have that. You want to make sure that the one you're joining does have that. Especially
in today's litigious society, you can't imagine how many people might take issue with some decision that's made and then decide that they would raise their hand and file a lawsuit.
That's right. And it can be on any variety of levels that someone might do that, but is there insurance to cover you for that? You want to know that.
Is that for a small nonprofit as well as some of the larger ones, which are more obvious that they would need coverage, even for a small one, David?
Yes, absolutely. I would. It's not a very expensive coverage if it's a small organization, but you definitely want to have that coverage. There are people who will disagree with anything you do or say in any role, never mind as a director or board member of a nonprofit.
If a director of a small board does something that is just wrong, unintentional, intentional, I suppose you do question which one it is, but if there is some malfeasance, does that mean that that person can be held personally liable apart from the board?
Well, yes, and it depends on the situation.
Sure.
So I'm not going to say yes, it's always that case, or no, it's never that case. But on a certain situation, there may be covered liability, but that's why you want to have the coverage.
And knowing that all nonprofit organizations need to have articles of incorporation and bylaws, there are three things that came across that were very interesting: the duty of care, duty of loyalty, and the other one is duty of obedience. Understanding that you should put the interest of the board above your own personal. Well, if someone is serving on a board, does that mean that they cannot be, should not be compensated for some services that they provide, even though they're volunteering plenty of time and energy and expertise?
So most boards at the beginning of the year will have their board members sign a conflict of interest form.
And if they don't, it's trouble, right?
It could be. It's the right procedure. So in that form, usually, if you do business with the organization that you're a member of, it's disclosed and everybody's aware of it, and the board can determine whether or not it's appropriate for you to continue doing business. For example, you may sell insurance to the organization, but they still want you on the board. Well, you were selling the insurance to the organization long before you were on the board. You've been asked to join the board. Do you have to stop doing the business? That's up to the board and the director of the organization and all of the people involved with. But if it's an arm's length transaction, it goes out to bid, and you're serving the board, the organization best with the lowest bid and the best coverage, as long as it's disclosed, it shouldn't be an issue.
That speaks to your usual comment, which is document, document, document.
Yep.
So as long as someone is likely to question, and they might, if there's documentation, we had 3 bids, this one's still the best coverage, best terms, whatever,
right,
then it seems that that would be considered a legitimate use of that board member.
Right.
Let's go speak to you as an attorney, David. So if you are asked to serve on a board because A, you're a good person, but also the board happens to need legal counsel, is there a conflict of interest with that? Or can you actually serve as their legal counsel for free legal advice when issues come up? How does that work?
You can, and it's not something I necessarily would recommend, but certainly as a board member and an attorney, you're giving information that may cross over into legal information. I always recommend that there should be an outside counsel for an organization other than the board members. I think it's the best practice. And at a meeting, many times I notice attorneys will really reserve giving an opinion. And I was on a board as a very, very young attorney with senior attorneys, and they would oftentimes say, well, I would defer to David on that issue. And I would think, oh, aren't they being very magnanimous and whatever? And then I'm thinking, oh, no, afterwards, they want me to have the liability, not them. But certainly, they were very well-intentioned and reasoned. And the point is that, of course, people, if you're an attorney, are going to look to you for your legal opinion. But I would tell you as a lawyer on a board, you can give your opinion, but then I would also say to the executive director, I would consult with the corporate attorney, the nonprofit's attorney, because they're the ones who are best in a position to give you actual legal advice. Would you have concern if the board said, gee, David, because you've got ESQ after your name, could you send out that letter on your letterhead? It'll look like it carries more weight. Is there an issue about that? Yeah, see, you wouldn't want to do that unless you are the organization's attorney. And if you're the organization's attorney, you probably don't want to be on the board, at least in that capacity representing the board. So, no, I wouldn't, as a board member, I wouldn't send out a letter on my letterhead representing the board unless there was a discussion, minutes to cover it all, and the consent of the board, the director, and everybody else that this is how we want to proceed. So interestingly, there are times when the nonprofit is held to even a higher legal standard than the for-profit. And here you, as a lawyer, have a very specific set of regulations within which you need to operate. Say, for example, I'm an advertising PR counsel. Would I be held to a similar stance situation where I should be very wary about what I offer as PR counsel? No, I don't think so. And here's what I think. Oftentimes, a nonprofit organization is going to look to have a diverse background of members. Yes. And for many good reasons. They want you for your marketing expertise. You're there not to tell the school how to market and do things, but to recommend. And as an attorney, I'm on the board to make recommendations from my legal perspective. The final decisions of what they do should be in the hands of their either hired professionals or the staff members who are in charge. The employees, you mean? The employees. But to give direction to them is the role of the board members, and the board sets policy, and it can set a direction. But if you're on a board and they're saying, this is how you should, asking you, what should we do about this marketing issue, you can give a recommendation. The board can either say, yes, we like that recommendation and vote on it, or it can just serve as a recommendation for the staff or employees, as you say, to decide how to proceed. And in no lesser sense, the plumber or electrician who serves on the board, he maybe could oversee and weigh in on the other
proposals that are being viewed, but he might be careful about whether or not he is the paid person delivering the service.
Sure.
Correct?
So he could be on the Buildings and Grounds Committee, and he could say, this proposal we have for this service is a good one based on my experience. Whether or not he's going to bid on it is a whole different issue that raises other concerns.
And if he has his son-in-law who's in the business, a related business, is that too close to the poison fruit?
Again, it's not that you can't do that. What's really most important is that it's disclosed and that it's a fair process. So if somebody is getting a job strictly because of who they are and their service is higher priced or not consistent with what actually needs to be done, that's where there's a problem. But if there's disclosure and it's a fair and arm's length transaction, you can do that.
The concept of inurement, it says that you're not allowed to take compensation in excess, essentially. Whose responsibility is it to deal with that? The board at large, the executive board? Does it depend on bylaws? Is that too in the weeds to discuss?
No, it's fine. It depends on the bylaws. Generally speaking, most nonprofits are set up with a board, and underneath the board is the executive director. And the only employee of most nonprofit boards is the executive director or the head of school or whatever that CEO position is. And so the board sets direction for the nonprofit and sets policy, but the executive director implements it. However, there are subcommittees to a board which will make recommendations to the board in setting those policies. And so there may be a compensation committee or a Buildings and Grounds Committee, or whatever committees that are necessary for the function of the nonprofit. And those committees, a finance committee, for example, will suggest to the board, this is what we should be looking at. And oftentimes in a big nonprofit organization, the executive director will get direction from the board, for example, for setting salaries for everybody else other than the executive director or head of school or whatever the CEO is, which compensation would be set by the board.
So these things theoretically should be written down. Also, the board has some responsibility to its newbie, its new member, to give them proper orientation and training. If you can read a balance sheet and a financial statement, that's good, but each board or each nonprofit may have its own way of listing what other expenses are or have its own way of breaking out a board. Does it make sense that you would need to, as the executive director or executive committee of a board, go through a line-by-line item, and that way you've covered your ability to say, now you do have fiduciary responsibilities because you get it, and you can't say that you don't get it?
You have fiduciary responsibility anyway, so what I would always recommend is at the beginning of each fiscal year or however your boards work, if you have new members, and even retraining for older or more seasoned members, to have an orientation. And at that orientation, depending on the type of organization you have, I think the finance person should take the board through, or the new members through, these are the reports that you'll see at the meeting, these are how we report out, these are what these terms mean, balance sheet, profit and loss, all of these different types of things, so that there is a good fundamental understanding of the finance. I would have, if there's a governance committee chairman or board, a subcommittee, someone from that committee to give an overview on governance and what your roles and responsibilities are. And I've been on boards where they do case studies and they give, all right, if this comes up, here's a case study, how would you react? And this is how you should react. And remember, there's a chair of the board or a president of the board, and there's a CEO or a head of school or an executive director. And these are the people who might be the ones that any problems that come up or whatever, you need to go back to and report back to them and let them deal with these issues. But just some training on what your responsibilities are, what you'll need to know, and what the issues are that you might be facing.
Sounds good. And another point of perhaps common sense, or maybe just weigh in on this if you would. Many board members are conflicted when it comes to their responsibilities and maybe crossing the line between giving guidance and micromanaging staff.
Yeah. So,
could you give some
I
perspective on that?
I just go back to what we said a little bit ago is the board has one employee, the executive director. Everybody else works for the executive director. So the board should not be going in and, let's just take that private school again, and telling the director of admissions, you need to accept this student who just applied. I know the family, they're a really good family. They don't work for you. You shouldn't be giving them, referring students, helping in whatever you're asked to help with, fine. But telling staff members or employees or whatever to do something, you don't have that authority and it's not your role. You go through the head of the board and the head of the school, if it's a school, or the executive director of the association. And so your role is to give a big picture policy setting direction as part of the whole board and not to act individually on behalf of the board.
These topics that we're addressing right now, it seems some of them would seem very reasonable and logical, and yet time after time, board members cross that line, don't know if they're crossing that line, and to offset that, there's suggestion that ongoing board development, board training goes on. And let's address one other topic in the brief amount of time that we have left about fundraising. Is it logical that if you are joining a board, you are expected to be a leading fundraiser, even if that's not really in your wheelhouse? Is that expected?
So when you're asked to join a board of a nonprofit, one of the things that should be discussed is what's expected for a gift, an annual fund gift, or however the organization does it. And oftentimes in the boards that I've been on, you're expected to make whatever board you're on as your primary focus for your philanthropy. And so what does that mean for that particular board? It's usually based on what you're able to do, and they want you on the board for other reasons, but they also want you on the board to make a gift.
And that's legitimate.
Yeah, and so what do they often say? We want your time, your talent, and your treasure.
Yes.
And so that's expected, and that's reasonable. And so there are different committees on the board, and if your strength is in asking other people for money, you don't belong on the development committee, but you're expected to be a good ambassador for the organization you're on and to lead by example.
It certainly makes sense, and many need to report out that some of their grants are contingent upon having 100% board participation. That doesn't necessarily mean the actual dollars, but just that there's full participation.
Correct.
Things that you need to know as you're joining a board.
Right.
We hope that this has been helpful to you. We hope that you continue to support your local charities and organizations as best you can. Thanks for staying tuned to The Law Matters. Please do stay tuned because it matters to you.